My name is Leena Heinämäki and I work in the Northern Institute for Environmental and Minority Law, Arctic Center, University of Lapland as a senior researcher. And today I'm very honored to have Nigel Banks with me. Nigel Banks works as a professor in the Faculty of Law at the University of Calgary, and he's a current holder of the chair of the Natural Resource Law. He teaches or has taught courses in property law, Aboriginal law, natural resource law, energy law, oil and gas law, and international environmental law. He was seconded to the Department of Foreign Affairs and International Trade in Ottawa as professor in residence in the Legal Bureau in the 1999-2000 academic year. And he holds an appointment as an adjunct professor at the University of Tromsø, Norway. In 2010, the University of Akureyri, Iceland, conferred an honorary doctoral degree on Nigel in recognition of his contributions to the development of Arctic law in the areas of natural resource law, international environmental law, and the rights of Indigenous peoples. Nigel Banks is the editor-in-chief of the internationally peer-reviewed book, The Proposed Nordic Sami Convention, National and International Dimensions of Indigenous Property Rights, that came out 2013. So in Canada, Indigenous rights have been tackled rather by national means than by relying on international developments. So can you describe the background and context to this?
Yes, well, I think it's fair to say that Canada has always had difficulty, I think, with the international legal instruments, particularly the ILO 169 Convention. And I think principally because Canada is a federal state. So I think there were always two objections to ILO 169 within Canada. One was from a concern on the part of the federal government that they would not be able to ratify 169 without provincial consent, and that would be difficult to obtain across the board. But also I think Indigenous peoples within Canada objected to 169 on the basis of the way in which it was negotiated and developed, because, as you know, it was the ILO is a tripartite institution involving governments, labour and employers, and Indigenous communities were not directly involved in those negotiations, and so I think there was quite an ideological opposition to 169 from Indigenous communities within Canada on that basis. And then you all also know that Canada voted against the adoption of the UN Declaration in 2007, and while it has subsequently endorsed that declaration, I think that opposition shows that there's a concern that Canada has gone its own way in terms of recognising, to the extent that it has, the rights of Indigenous communities, and has not been thinking that much about the international legal context.
Mm-hmm. Yeah. So do Canadian courts actually refer to international human rights and Indigenous rights instruments generally at all, or some cases?
Well, I'd say generally courts refer to international human rights instruments, but not certainly historically in the context of Indigenous communities and Indigenous rights. And there I would say that, and at least until the adoption of the UN Declaration, there are very, very few references to international instruments. I mean, I guess I would say clearly and obviously no reference to ILO 169 because Canada isn't a party, but also very little reference to the International Covenant on Civil and Political Rights, and I think no references to specifically Article 27. I think, and that I think is difficult to explain, and it must partly, I think, actually relate to something deeper and maybe to do with the education of lawyers in Canada, and perhaps tells one that we are very much an internally focused legal community than an externally focused legal community. However, what I would say is that since the adoption of the Declaration, there have been increasing references to the Declaration. I would say no references that in a sense have made a difference to the outcome of the litigation, but I think what we are seeing is the sort of increased internationalization of the discourse on Indigenous rights in Canada. And I think it's interesting, even the language, right? Canada historically has always used the language of Aboriginal rights, and I think increasingly at both the Indigenous political level and within the non-Indigenous political community, we're seeing increased reference to Indigenous rights, and of course that's the term used in the UN Declaration.
Yeah, that's quite interesting insight.
Yes, I think it is, yeah.
Also, the fact that the UN Declaration has had such a big effect, like we are often discussing that it's a non-legally binding, but it has this indirect and certain political and awareness-raising implications.
Yes, and so when you say a big effect, that's the effect I would ascribe to it, that consciousness-raising, rather than, it's hard to say it's had any legal effect at this stage, but certainly the discourse is all free, prior, informed consent and issues and language taken from the UN Declaration.
Yeah, interesting. So how about, do any land and self-government models derive from international standards? Is there any, they are totally based on a national?
I think it's fair to say that they really are made in Canada solutions to the pre-existence of Indigenous communities within Canada before its political creation. So there's always been some reference to US case law within Canada, particularly on the recognition of Aboriginal title. But I think the modern approach to land claim negotiations is a made in Canada approach, and I think perhaps the best evidence of that is, if one thinks historically, the most recent major settlement of Aboriginal claims in the United States is ANCSA, the Alaska Native Claims Settlement Act of 1971, I think it is. And ultimately, of course, that is a legislated settlement. It's a Congress bill that settles that land claim, whereas the Canadian approach has been very much negotiations leading to the big modern land claim agreements, which were ultimately ratified by Parliament, but which were based on negotiated agreements.
Okay. So then, talking about the land and self-government arrangements, what would you describe as the basic elements of modern land and self-government arrangements in Canada, and maybe you can give an example of a rather advanced model and then a more moderate and older model that there exists?
Okay, so if one looks back at relations between Indigenous communities and the settler state in Canada, there's this period of historical treaties running from the 18th century through to the beginning of the 20th century, and then really a gap. So the period of modern land claim agreements in Canada starts in the mid-1970s with the James Bay and Northern Quebec agreements, and that process is an ongoing process. So and it's really concerned with those parts of Canada where there were no historical treaties. So this really means Northern Canada, Yukon, Northwest Territories and Nunavut, large parts of British Columbia and parts of Eastern Canada as well. And so the main elements of those agreements would be a recognition of title to land, in some parts of the traditional territories of these Indigenous communities, and at the same time the recognition that other parts of those traditional territories are state land or crown land, as we would term it. So there's a land settlement part of it, designed from the government's perspective to provide certainty as to who has the better title to which land, and then typically a series of co-management arrangements for the entire area of the traditional territory. So these co-management arrangements would include arrangements in relation to land use planning, environmental assessment, water management, and wildlife management. So a series of co-management bodies involving the Indigenous community and typically one or more governments, so the federal government and a territorial government or a provincial government. And then also there is typically a set of provisions dealing with economic development as well, which might involve both financial transfers and also preferential economic opportunities for Indigenous communities within the settlement area. So I guess these are complex agreements, typically covering 200 or 300 pages. And I guess the more modern agreements also deal with self-government arrangements. So you asked for some examples. So an example of an older agreement that doesn't include self-government would be the Inuvialuit agreement. So this is an agreement relating to territory, partly in the Northwest Territories, partly in Yukon at the mouth of the Mackenzie River in northern Canada. So that's an older agreement. I think it dates back to 1983. And then two more modern agreements which I think are interesting from a comparative perspective. One will be the Niska agreement, which is early 2000s, I think, and that's significant because it's both it concluded a long-standing set of negotiations covering some would say a century, but maybe certainly the last 20 years, following a key piece of litigation which is known as the Calder case, dating back to the 1970s. So it's significant historically, but also because it includes self-government as well as the settlement of title lands. The other agreement I think that's worth looking at is the Labrador Agreement. So this is an agreement between the Labrador Inuit and the province of Newfoundland and Labrador and the federal government. And what's interesting about that is that also refers to self-government, but it's what we would refer to as a public government model. So very much like the Nunavut model. So a recognition that the Indigenous government has authority really over a broad territory, and not just in a sense over its own lands, but over lands that are sort of partly public, partly Labrador Inuit lands.
So you already partly covered or mentioned about these co-management models, but if we go a little more deep into this, like are there also situations in Canada similar to Finland where Indigenous and non-Indigenous populations live side by side and use nature in a very similar way? Like are you aware of any co-management models that are not solely based on Indigenous exclusive land use? I guess you partly already answered that, but like where they give also right and possibilities for other local populations also to use land for traditional purposes such as hunting and fishing.
Well, I can't really speak to the Finnish situation, of course, so I'm not going to do that. But I guess I would say, well, first of all, these modern land claim agreements tend to be in northern areas where the indigenous population is a dominant population. So in Nunavut, for example, the Inuit population is about 80% of the population. In Yukon, though, the First Nation population would be a minority. I think something in the order of 30% of the population of Yukon would be First Nation. So obviously we are looking at situations where indigenous communities are living side by side with non-indigenous settlers who have moved into those territories. And clearly some of the members of the non-indigenous communities are engaged in similar activities in some cases. We don't have a history of reindeer herding in northern Canada. There's some isolated historical examples of introduced reindeer herding. So it is more of one might describe the traditional economy as a hunting and trapping economy. Clearly there are members of the non-indigenous community who are involved in those activities. So I guess I'll answer your question by saying, how is that dealt with in modern land claim agreements? Well, these agreements are designed to recognize the rights of indigenous communities, so they don't contain any express reference to the rights of the non-indigenous communities. But what they do is, in some cases, certain populations would effectively be exclusively reserved to indigenous communities for harvesting purposes. That would be particularly the case for marine mammals, which is pretty much exclusively harvested by Inuit peoples in Canada. But then in relation to other resources, whether these were fish resources or land mammals, bears and other similar species, typically, or caribou, what the agreements provide is for a preferential harvesting right for indigenous communities up to something that's referred to language like the basic needs level of communities. So the idea is that indigenous communities are recognized to have the right, which can be effectively an exclusive right up to a certain harvest level, to provide for their economic needs, but also their social and cultural needs. And so that's the way those issues are dealt with. And in terms of co-management, the co-management boards and authorities recognize or provide for the participation of the indigenous community, the territorial government and the federal government. There's no express provision for participation by non-indigenous harvesters. But I guess the assumption is that their interests will be protected and recognized by the public government participation on those co-management bodies.
Yeah, it makes sense. Then maybe to sum up a bit, like how would you generally describe the legal situation of Indigenous or Aboriginal peoples in Canada when you compare it to other countries that have large Indigenous populations, such as Finland? What would you? It's a very broad question, but to sum up a bit.
It's a very broad question, so it's very difficult to answer. So maybe I'll answer it in a couple of ways. First, by saying, and this goes back to the first question, that Canada is, I think, less outward-looking, less international in the way that it thinks about its relations with Indigenous communities. I think that is changing. As I said earlier, I think the discourse is becoming more internationalized and more influenced by developments in international law and discourse. So that's whereas I think when I look at Finland, I see or Sweden or Norway, I see countries that are very much thinking about the international context for their relationship, even though I know Finland has struggled and Sweden has struggled for a long time with the possible ratification of 169, it does seem to me that Finnish courts, in particular, take seriously Article 27 of the International Covenant. And so that's why I would say I think the Finnish legal system, in its consideration of the position of Indigenous communities, is more internationalized. I guess the other thing that I would say, and this is more of a comparison through work that I've done with Irvin Ravner at Tromsø, thinking about the way in which Canada has approached the recognition of Indigenous land rights. It's very much a sui generis approach. So the Canadian courts have really created from sort of whole cloth the way in which we should develop tests for the recognition of Indigenous land rights. Whereas the Norwegian approach, and I think the Swedish approach, is very much to apply old principles of property law, of long-term possession and use, as a way of thinking about how to accommodate Indigenous rights. So it seems to me that's a significant difference in terms of approach. I guess the third thing I would say is that Canada ought to be more influenced than it is by developments, and we haven't mentioned this before, within the inter-American community, because Canada is a party to the Organization of American States. It's a relatively late joiner, but should be influenced by the jurisprudence coming out of the Inter-American Court and the Inter-American Commission on Human Rights. And I think that's another development that we'll see unfolding over the next years and decades.
Yeah, that's certainly a new insight also for me to think about the Inter-American courts and that implications in the Canadian system. Wow, so we got a really good insights. I'm very pleased and honored to have you to talk about these things in Canada, and they certainly give also comparative interesting points to look at in terms of when in Finland we are trying to find models to bring Sami rights further. So,
okay.
Yeah, so thank you very much.
Thank you, Leena. Thank you.